thanks for coming up the stairs. That was the first challenge. The second will be on our side. It was already challenging to do a cartel investigation simulation in 45 minutes. Now, I don't know how much we have, but we'll go directly to the substance so that we can have most of the time that is left before the break that everybody certainly expects. And so, breathe after such a climb. Okay, well, so all four of us are partners at Mayer Brown. Maybe just a quick word just to tell you where we are based. Christian and I co-head the European antitrust practice, whereas Early and Britt are antitrust litigators doing class action work, in particular, respectively, in the UK for Early and in the US for Britt. And as you certainly have seen, many of these cases today of cartel investigation start with a dawn raid, but you never know where it will end. And very frequently, very rapidly, class actions are started. And our view in the team, based on our experience handling these international investigations, is that you need to have that in mind from the very first minute of the dawn raid. That definitely calls for preparation. And here comes the idea of our simulation. So, directly to the point, we took a hypothetical case. Any resemblance with any of the past cases of the few months would be completely fortuitous, obviously. So we have two companies, two big beverage soda companies, two big players. One is bigger than the other. It's Beverage Co. And Beverage Co. is a US-based beverage company, but it has activities worldwide. And, well, they are very interested in the new kid on the block. The new kid on the block is Best Pop. Best Pop is a listed company, European-based, and Best Pop has been around for a while. It is growing. It is even starting sales in the US these days. So BevCo has been on the watch and has started acquiring a minority shareholding back in 2022. Nicely enough, this acquisition was under the thresholds in the jurisdictions where minority shareholdings are reportable, so no filing obligations. But in 2025, they are ready for the big game and to acquire control over Best Pop. They launched a tender offer. And they now have to file in many jurisdictions, in Europe mainly, and notably at the EU level. The process is not too long, as you can see, because merger clearances are obtained less than 6 months after, and everybody in the room handling merger cases in Europe knows that it can frequently be 6 months or even longer, especially with such an important global player and a new kid on the block. But this is obtained, although the European Commission asks for loads of information, as they frequently do, and they notably ask for two type of information, two big RFIs. One is about all exchanges between BevCo and Best Pop in the period between 22 and 25. Could be interested in potential coordination between the two companies at the moment where they were supposed to continue to compete. Second type of information they are calling for is all the earnings calls that BevCo has given to investors to explain the good reasons to invest in BevCo in this period. And so they have to provide transcripts of all these earning calls. But they never hear back from those documents that they send to the European Commission up until one day, and that day is the very day that we are today. So the public offer is finished, the merger is implemented, both companies have closed their files working on integration, and that's where inspectors from the European Commission knock on the door. There's an inspection decision that mentions two likely infringements for which the European Commission has gathered elements. First, a potential agreement not to hire each other's employees between Bevco and Best Pop between 22 and 25. We've discussed that downstairs. And the second potential infringement, based on listening to the earnings calls, is price signaling between the two companies, also during that period. And it may very well be, that's what the inspection decision, that this does not only concern Bevco and Best Pop, but other players in the industry in Europe, and possibly wider. So a complicated day, if not a fortnight, starts in two premises, the ones in Europe of the two companies, one in Brussels for Best Pop and one in Spain for Bevco.
So EC inspectors focus immediately on electronic data and ask to place legal holds on several executives' accounts and to obtain copies of their Outlook data. The data is stored in the UK, so outside of the EU. EC inspectors also obtain personal and professional mobile phones of several execs and ask for access to the WhatsApp messages of the Spanish CEO, who just happens to be travelling in India at this time. And the inspectors have therefore not been able to take his phone as they have for the other executives concerned. So, Christian, faced with this, how should a company manage requests for data located outside the EU? What is the company obliged to do, and what are the risks of refusing access?
Yes, that's indeed a very important topic, and very likely those of you who attended dawn raids in the past were often faced with this basically initial issue, which is accessibility of the data. Because very often, in particular in this surprise situation of a dawn raid, we see that the companies initially are unable to give access to the data, to the emails, for example, in particular if those are stored outside the EU. Yeah, because there's obviously very often the initial reaction, look, our server is somewhere in the UK, like in this case, or even, for example, in China, and we don't have the technical possibilities to access this data. And by the way, since it is in China, there cannot be any obligation. And there was an important decision of the General Court last year, which really provided, I think, important clarification on that topic, because the president of the GC has kind of ruled in an interim proceeding that there is indeed an obligation for the company to make available those data which are stored outside the EU. In that case, it was indeed China. It was also a quite interesting case because it was not a cartel investigation. It was a FSR investigation. So it was the first dawn raid in an FSR case. In the typical FSR scenario, a Chinese company was targeted. So the inspectors requested the content of several email accounts of employees, which were all Chinese citizens, and the company argued those email accounts are stored on the server in China and there is no possibility, and they said there is no obligation from us. And the commission requested it, then they filed this interim proceedings, and then in very, I would say, clear words, the president of the GC said there is indeed an obligation to make accessible those data, even if they're stored in China. Then even the company tried to argue they would breach Chinese criminal law. Even that did not impress the president of the GC, at least in the interim proceeding. So, and in the reasoning he said, this has to happen, because otherwise, if companies would not be obliged to make available those data stored outside the EU, it would be very easy to circumvent for every company by just kind of relocating all your data to servers outside the EU, and then basically you would be immune from any kind of dawn raid. So that there we have clarity. So this is basically not an issue anymore. Of course, often we see technical kind of problems, yeah, and that often also trigger, I would say, tension in the investigation, because often it takes quite long, in particular if servers are abroad. So therefore it's really important to kind of keep calm, and in particular explain to the inspectors very detailed what are the technical reasons why the data cannot be immediately downloaded, or what are maybe other circumstances. One last option could be, even if that's not possible immediately, to kind of already offer to the inspectors to put on a legal hold. I think in this NUCTEC, in this Chinese case, it was even then also agreed with the Commission until that is clarified. So with a legal hold, you can then also ensure that kind of the data at least remains frozen in a way.
And just touching further on the request for legal holds, what are the risks if the company gets this wrong?
Yeah, that's another risk similar to the storage, because there again we have a risk of obstruction. So legal hold is basically freezing the data on at the time when the legal hold is put in place. This is a tool which is very often used, though it's not regulated in the regulation number 1, or there's no kind of legal or not yet any legal basis. We currently see in the consultation for the new regulation number 1 that apparently the Commission is considering also putting in the regulation a kind of formal tool for the Commission to kind of request such a legal hold, but that does not exist yet, though it's often practiced and also sustained by the Commission. So there it's indeed important to do the legal hold right, so that it basically freezes all the data, because obviously you have during the dawn raid always the risk of obstruction that employees then try to delete certain emails, and therefore the legal hold is really important. But again, a bit similar like in these previous questions, it is important that the IT departments and also the response teams working then on the dawn raid are kind of properly trained, that they know how to put this in place just to avoid the risk of any obstruction. But obviously this is also only the legal hold is only something with which you can ensure that documents or emails cannot be deleted, though there might also be other information relevant in a dawn raid.
And Natalie, what about this request for WhatsApp, though, particularly bearing in mind the Spanish CEO who is temporarily in India? What is the company obliged to do, and what are the risks?
Well, WhatsApp is... can you hear us real well? I was wondering, is it okay? Okay. So WhatsApp is of utmost interest for inspectors. For a long time, some business people have thought that it was encrypted, so very secure towards authority. It isn't, as certainly we now all know in this room. And so that's the one thing they are interested in the first place, all over the world, not just the European Commission, and they want it as soon as possible, because the legal hold mentioned by Christian is of no use. WhatsApp, or name it, Messenger, Signal, all these apps are personally controlled. The company normally has no copy of the backlog of conversations, because it's considered a personal app. It's personally created, and therefore when the Commission asks for it and the person is not here and you can't get hold of their phone, this creates a lot of tension. And these apps raise, I think, at least two issues. This no control of the company, and the second one is that it's full of personal data, and not just personal, very private, intimate data, because these apps are, for most of us, mainly used for personal conversations, very personal conversations, and only on top of things for professional ones. And this can lead, maybe we can go into a few field stories. One I remember well was in a recent EU inspection, where once the European inspectors mentioned WhatsApp, all the staff went terribly nervous. Because, and after a while they explained to us, and then we explained to the inspectors, that they had a conversation between themselves to gather elements to build a harassment claim against their boss. And so if that was taken by the inspectors, it would be seen sooner or later by the company, and they would be uncovered. So a lot of tension. It's typically in those cases that some employees are likely to delete things. I also have field stories about affairs leading to destructions, and that creates some tension in the process. That time, the European Commission, it was 2 years ago approximately, and the European Commission did the thing well. They agreed to take it out from what they took. Because the General Court has done, and the court itself have done a number of things since then. We've had the French supermarkets case, where we've challenged the inspections for several reasons, and in particular because they've handled with absolutely no care the personal data of the persons in the room. But what the General Court said is that if you want to have a ground, you only have a ground for appeal if you immediately rush to the General Court and launch an interim measure application. How nice the Commission does inspection for 2 weeks so that it gives you the time to rush to the court and launch an interim measure application to obtain better protection if the Commission hasn't done it. So here what is likely to happen is that the Commission will ask that person to come right as soon as possible back. When that person lands in Brussels, he has to come to the premises of the Commission and then hand over his phone. The problem is that in the meantime, you don't have 1 hour or 2 hours. You have several days where the temptation will be huge to destroy things. And that we know from the fragrance case, in which a company has been fined 16 million euros. It's not sufficient to write to that CEO and give instruction not to delete anything. It's absolutely insufficient. It's what the company had done. It was fined because the executive, even informed by its GC, deleted WhatsApp conversations. The only protection for companies is to train people on a very regular basis so that they know the risks. In some jurisdictions, including France, where I come from, there's even a criminal risk for the person. 16 million euros fine for the company definitely matters as well. So that's what's likely to happen, and preparation is absolutely key.
So, Natalie, you said that you've got regulators on premises for 2 weeks, but about an hour into their investigation, an hour into their inspection, they start handing out a memo that encourages you to take leniency. Do it now, right now, because if you don't do it now, someone might get to it first. You're trying to do your own investigation on behalf of the company while the regulators are on site. Can you still apply for leniency? 2 days in, 3 days in, a week in? Is there still an opportunity for leniency at that point?
That memo is really famous. Yeah, that memo of the European Commission has a lot of drama effect when it is handed out. So it's a one-page memo explaining to you, you'd better go for a leniency just right now. And it's handed out generally after 30 minutes or an hour. The impact on companies is huge. And indeed, at that point in time, very frequently, we've just arrived on site. The GC does not necessarily know about the presumption in the, that are stated in the inspection decision. So, yeah, we definitely have to work our way before triggering a marker to the Commission. But everybody's doing the same thing at the same time. Well, I've done it once to apply for leniency during an inspection, and not at day 14, 3 hours after it had started. But we were very lucky because we had on the premises the president of the company, who knew it all. So I won't tell you which case it was, who knew it all. I will need to blur a few details. The president of the company, the GC, also knew about it, and being all in the same room, we've been able to make a decision pretty rapidly. What we could tell from the inspection decision is that there was a first leniency applicant, by the way, in that case. And the paper trail was apparently very limited. All they could use were statements by the first leniency applicant. 3 hours after the dawn raid started, we applied for a marker, and at the end of the day, we obtained a 40% reduction, precisely because of that reason. It was mainly statements by the first leniency applicant, and we confirmed the story of the first. So we obtained 40%. But doing this while an inspection goes on is really a challenge, and that's where knowing the company already is really of essence, so that it goes fast.
Okay, Christian, so Natalie's put in her leniency application, so that's in the books. Does that protect you from remedies? Does that protect you from major risks that you may have along the way? Once you've got your leniency application, is it done?
Unfortunately, not really. I mean, of course, a leniency application protects you from very high fines, as Natalie has just explained. So usually, if you're really the first one, then you get full immunity. If at a later stage, even during a down rate, you can still receive a quite substantial reduction of the fine, but it, in general, does not protect you, of course, of the second pillar, not the public enforcement, but the private enforcement. Because also, of course, damaged claimants can go after a leniency applicant, and basically that's also one of the reasons why the number of leniency applications, or at least in the view of some competition authority and legislators, decreased significantly over the last years, because companies felt the risk of damage claims, which are in some cases even higher than the fines. And even if you get a reduction of the fine, if you then pay the double in damages, then it does not help. Of course, there are certain measures which have been put in place, at least on the member state level in the European Union, following the damages directive, so that leniency applications and documents are not disclosable, yeah, which of course already helps. But of course, there's always a lot of content then in the final decision, which may also relate to the leniency applicant. So there is indeed a risk that also the leniency applicant will be faced with kind of damage claims. There are some jurisdictions, for example, in Germany, my home jurisdiction, where there are also some possibilities to limit the possibilities of claimants to go after the leniency applicant, at least to go after the first leniency applicant, so Kronzeuge in German law. So the first who then basically gave the competition authority the information to which they were not aware of. So only those who get full immunity. There, the possibilities to sue for customers or other market participants are limited. So you cannot, for example, sue a company with which you do not have direct relationships. That's explicitly provided now in the German law. So this is one, of the kind of limitations which helps. But overall, it of course also does not fully prevent those leniency applicants from any kind of private enforcement claims. So, and this maybe, and in particular in this case here, where we have kind of companies involved which are active not only in the European Union but also in other countries, obviously there's also risk that then through a leniency application in the European Union, information also becomes available which relates to effects in other countries where we possibly have regimes which are more stricter or more severe, like for example in the UK, where we see that there's a lot of things going on. So where also a down rate in the European Union can impose kind of significant risks on companies on the private enforcement side in other jurisdictions. And then of course, final point, it's also always important kind of to keep in mind not only in this case the kind of acquirer is searched and there are documents available, but also from the target. Yeah, so basically you also have to keep in mind that there may also be incriminating kind of documents or information from the target. So you have to basically make sure that you also prevent those information then also later to be used in any private damage claims.
Thank you, Christian. So within the EU, leniency applications are protected, maybe not 100% bulletproof protection, but the leniency statement itself enjoys significant protection. It is oral before the Commission, as you may know. At least you can ask for it, and you're protected by EU laws. But we've seen with interest a practice that has developed in the past cartel investigation started by the European Commission, where a few days after, generally a week, a class action starts in the US, and it could possibly as well happen in the UK. And among the benefits of litigating in the US, which you will talk about, Britt, I suppose it's also a way to try to have better access, easier access to leniency documents. Is that the case, Britt?
Yeah, I don't know if I would say that it's a benefit of U.S. litigation. No one wants to be in the U.S. because then they're going to inevitably have to produce more than they want to produce. I'll say to sort of set it for purposes of this discussion, we're going to assume that there's no DOJ investigation such that you haven't already produced all these documents to the DOJ or the FTC, and you haven't had to go through a merger clearance in the US and gone through a second request, in which case, again, a lot of these documents may be already in the US. Because once the documents are in the US, it's much easier for civil plaintiffs to get access to them. Whether it's through a subpoena process, whether it's through bringing a class action. Once the documents are physically in the US, you have a harder time shielding them from discovery. So let's assume they aren't already there. This is all happening over in the EU. It's over in the Brussels location. It's over in the Spanish location. Nonetheless, the civil plaintiffs are going to want to try to get a hold of them. And in the U.S., U.S. courts generally follow the federal rules of civil procedure, which are obviously unique to the U.S. And the standard in U.S. courts is whether or not the documents are within the possession, custody, or control of the entity, i.e., can this company produce them essentially on demand? And so that's going to be one of the discussions that's going to be had, is whether or not, even if you are addressing the discovery request to a US-based subsidiary of one of these companies, can they get a hold of the documents on demand? That can be enough to find a finding of control. If you can get it on demand, well, then you have control over it. So when it comes particularly to the leniency files, you want to draw sort of two distinctions between the leniency application itself and then all of the documents you submitted in connection with your leniency application, because the standard that's going to apply to them can vary. The leniency document itself is going to be given the most protection. I would nonetheless, and I often counsel clients still, if it doesn't need to be in the US, don't send it to the US. You should really treat it with the level of seriousness that you would otherwise treat it. So if it doesn't need to be in the, I was about to say if it doesn't need to be here, if it doesn't need to be there, don't send it there. But separate apart from that, the EU has made it pretty clear, and the EC has made it pretty clear, that the leniency document itself occupies somewhat of a protected status. And in some instances, they will send letters. They will, on rare occasions, even show up as amicus curiae in US courts to try to prevent the production of the actual leniency document, because that's part of their investigative process. They want the ability to be able to encourage people to come in through lenient applications and to participate in the process and otherwise cooperate with the EC in its investigations. And so it tries very hard to protect those actual submissions. And the US courts as a general rule try to be as deferential through comity concerns and otherwise to respecting the sanctity, to a certain extent, of those actual submissions. But that deference is somewhat narrow. And by that I mean, if there are documents that have been submitted to the European Commission in connection with a leniency application, and those are pre-existing business documents that weren't created specifically for turning into to the EC, but are pre-existing business documents that are going to show all of the emails back and forth between Beverage Co. and Best Pop, that are going to show planning documents that Beverage Co. has about its possible acquisition, or about what it might do in the marketplace generally around pricing and otherwise. I think Nathalie in in the discussion of what the European Commission is looking at, it's not just the acquisition, but possible other anti-competitive conduct in the marketplace. All of those business documents that were submitted to the European Commission are ripe targets for discovery in the U.S. The plaintiffs are going to seek as soon as they possibly can to get a hold of those documents. Depending on the court, depending on the case, depending on sort of the relative jurisdictional issues that are going to face the parties, the court may or may not allow discovery at the outset on those issues, but it can. We have a recent case in which we were involved in which there was a U.S. case filed, there was a European investigation going on, and between the time the U.S. plaintiffs filed their case, they immediately asked for discovery of all of the pre-existing documents that had been submitted to the European Commission, and the U.S. court said, yeah, okay, that's fair game. I'm going to let you have the pre-existing business documents. They got produced. It went to jurisdiction, and whether or not the U.S. courts had jurisdiction over the non-U.S. entities. And so as part of, and certain aspects of the submission to the European Commission to see whether or not, in fact, the alleged conduct was actually had an impact and could have a role in the U.S. proceedings, but said, okay, those documents are fair game. I'm going to make you produce them. And sure enough, plaintiffs did exactly what you would expect them to do. They used those documents to beef up their complaint. And they filed an amended complaint that suddenly had all of this really interesting information from a bunch of documents they otherwise might not have gotten a hold of, added that to their complaint, and sure enough, the complaint survived a motion to dismiss. We were off to discovery, and the game was afoot in the U.S. At that point, all sorts of discovery started. There were all sorts of additional discovery requests aimed at getting additional information and deposition testimony around the facts and the documents that were at issue. Again, they didn't get a hold of the leniency application itself, but they were able to get pretty much everything around the leniency application. And so they will come at it in as many different ways as they can come up with, and I'll say they're pretty creative in terms of how they will go after, and they will go after it whether or not it is sitting in the EU, whether it is sitting in the UK, wherever it is sitting, they will seek to get a hold of it. And the U.S. courts, particularly where there are situations, and we could spend a whole afternoon talking about the FTAIA and whether or not the conduct at issue had a direct, substantial, and reasonably foreseeable effect on U.S. commerce. I've just lost half the audience with that, but that could be an entire discussion in and of itself. But when you start talking about those questions, the more discovery is going to be asked for and the more discovery is likely to be produced. And Bevco in this scenario is a US company. So there are very serious repercussions if you don't agree to produce it. There are severe monetary penalties that can be assessed. There can be adverse inferences of what those documents might have said had they been produced. So the reality is Bevco is going to comply. It's got a lot of, under our scenario, it has a substantial U.S. presence. There's no question of jurisdiction. And so these documents are very likely going to get produced. So everything short of the leniency application is there. So the U.S. plaintiffs will essentially be able to reconstruct what was sitting in the leniency application, even though they don't have the actual document itself.
Bad news?
So, as with many aspects of antitrust litigation, there are many parallels between what has been happening in the US for a long time. The UK is playing something of catch-up. I'm not sure how much of our audience has followed along with what has been happening in UK antitrust damages litigation of recent years, perhaps apart from Washer and Richard Wish and some perhaps colleagues from the London office of Hausfeld who are here. But we've had a massive uptick in recent years in follow-on damages claims in class actions, but also increasingly standalone claims that are started with a mere whiff of a dawn raid, for example, which then run either in parallel with the investigation or in some cases even running ahead. So it is really important for this thing to be discussed across jurisdictions as we're doing. Now, on one level, in the UK, the answer is straightforward and good news for Beveridge Co and Best Pop. I should say that there were some important legislative changes introduced in the UK on the 8th of March 2017. So everything I'm going to talk about from now on is post-dating that because of our particular factual scenario. But since then, direct access to cartel leniency statements and settlement submissions is barred by statute. But because we are lawyers and economists, of course the answer is more complex than that. The devil lies in the detail as ever. The statutory bar applies to any information voluntarily given to a competition authority, so including the European Commission, specifically for the leniency program, and whether or not that leniency statement or settlement submission has been withdrawn. Courts and tribunals in the UK are then prohibited by our Competition Act from ordering their disclosure. Further good news for Beveridge Co and Best Pop, they are also protected from workarounds like freedom of information requests or Norwich Pharmacal applications. However, Beveridge Co and Best Pop would do very well not to assume that this is a bulletproof, ironclad wraparound protection. There are some very clear exclusions to that bar, and you're about to hear some language that mirrors exactly what Britt was talking about before, but from a UK perspective. So still subject to disclosure, any of that pre-existing information or documents that's expressly carved out from our legislation for what is protected here. So regardless of whether it is, for example, appended to or disclosed alongside a leniency statement, if it existed at the time of the underlying conduct being investigated, it's expressly carved out from the protection. So all those WhatsApps and contemporaneous emails we were talking about before, they're fair game. We then enter what I think of as being the grey zone of information that may be vulnerable to disclosure. And it's for the court to determine whether or not such information is disclosable, whether it forms part of a leniency statement or settlement submission and is so protected from disclosure. So documents provided to the authority as part of its investigation, such as witness statements, evidence and admissions made outside of the leniency statement, may well be disclosable. And in private damages actions, the court or tribunal can order disclosure of such materials, but only after the investigation has finished and only if it meets a proportionality test. So for that, the court or tribunal in the UK will also have to be satisfied that it is necessary and proportionate that they be disclosed, applying the normal balancing test for disclosure in any event. So including a comparison of the likely relevance of these documents to the matter at hand against the costs and efforts in providing that disclosure. So just drilling down a bit here, a party seeking what we call train of inquiry disclosure, that's disclosure that is for the purposes of identifying further areas for potential disclosure. This would require a very strong justification, we say in the UK, but the Competition Appeals Tribunal, or CAT as we call it in the UK, has recently found in the car safety systems cartel litigation that a situation where claimants are alleging a cartel infringement might well be justified in seeking disclosure of those documents because the underlying facts would be unknown to the claimants but will be in the hands of the defendants. Now, the English court's powers to order disclosure also extend abroad. Parties to English litigation are generally required to disclose relevant evidence that they possess or have in their custody or control, regardless of whether those documents or parties are located. They're also required to disclose documents held by third parties, wherever they are, from whom they are entitled to demand or request copies of documents. The obvious example would be a parent company that wholly owns a subsidiary which holds relevant documents, but in each instance it will come down to the specific facts of the case at hand as to whether that entitlement or control actually exists. Now, it's worth noting that the cost and effort required in providing these disclosures is most likely to fall to the defendants. English courts will only order a competition authority itself to disclose those documents if a defendant or another third party can't actually provide the disclosure themselves. Now, drawing all of these threads together, we end up in a place much like Britt's description of where you end up in the US. What we're seeing in the UK in recent years has been that there are increasingly sophisticated claimant firms who are very adept in these private damages claims, and they're very adept at obtaining maximum disclosure, and then by seeking the contemporaneous documents, as you said, straight off the bat, but also going after these grey list materials, not just from defendants, but also third parties, and then extracting from that collection of documents the maximum amount of information they can, triangulating, and then ending up pretty much with what they probably would have got out of the leniency statement, but for the statutory bar.
Thank you very much. My name is Balin Basola. I'm from Budapest, Hungary. And I would like to ask our colleague from the UK whether, in your view, discovery is working well in the UK. Whether that's efficient and what is your experience? Thank you.
Of course. I should say that I am always on the defendant side of these things. So my view may well be coloured when I say it can always be improved. Disclosure in antitrust litigation is notoriously difficult and burdensome. And as claimant firms are adept at seeking maximum disclosure, so on the defendant side of the coin are we very adept at resisting as much as possible what we shouldn't really have to give over. But I would say absolutely it can always be improved. The CAT has had this explosion in class actions cases in the private damages sphere in the last few years, but private damages actions have been quite significant before that, and the burden of disclosure on defendants has only been increasing and becoming more difficult. So I think it's an area that's ripe for reform.